Hi guys, welcome back to the channel. So could you possibly receive a letter of inadmissibility or a ban letter from RCIC without receiving a procedural fairness letter first? Actually, you could, and this is not the ideal situation, but a ton of cases I have handled in the past, and I'm still working on few of them where people have received all across the world the direct letter of inadmissibility without getting even an opportunity to understand what really the issue has been or why they have received that letter of inadmissibility in the first place. So just to understand the context a little bit, the term called a procedural fairness letter, which means that IRCC want to maintain the fairness of the process. So as a matter of fact, the clear analogy will be you have a court system. So if somebody is saying that, well, you have done something incorrect, the court cannot send you to jail. The court needs to give you, the court needs to hear your part of the story before giving a decision. That's exactly why the fairness of the process need to be maintained. Your principle of natural justice will have to be impact. The right to decision, the right to be heard will have to be abide by. And that's exactly why the concept of procedural fairness coming into picture. Not a significant number of cases, but definitely a good number of cases that I have seen where people receive a procedural fairness, a letter of inadmissibility directly. My advice to them, and at least from my practice of the successful cases of those nature, is that if you are into that kind of a situation, please send a letter of reconsideration to IRCC as soon as practically possible. I would literally stress on the term as soon as possible, because if you delay it, let's say by a month or two, that is going to having a detrimental impact on your case. Now, if you are following this channel, you know that I am a big proponent of the fact that a reconsideration really does not work, because that's not really a legal process. But when the fundamentals of procedural fairness and the natural justice have been breached, you deserve a right. It's your fundamental right to let IRCC know, and again, as soon as practically possible, that hey, what's the issue? You have sent me this letter. Where is the fundamentals of principle of natural justice? Where is my right to be heard? Where is the basis of your decision making? I don't even know really the issue, and you sent me on a letter of inadmissibility. That is just not fair and just. So you should prepare a legal reconsideration request as soon as practically possible. Send it to IRCC either through email or through a web form. And mind you, just raising a web form or just sending an email is not going to be helpful. You have to be persistent with your approach. You have to follow up with them inconsistently within after some specific duration of time, and that specific duration of time varies from one embassy to another, from one country to another, but you have to be persistent and consistent in your approach. And I could tell you that at least the cases that I've handled of this nature, 7 out of 10 people have their file reopened and have got a decision which could be a refusal of that application, because that is a separate case. But those ban or the inadmissibilities have been reversed. So this is a very critical and serious and life-changing kind of a situation, at least in my opinion. If you're into that kind of a situation, more than welcome to hop into our website, nuvonation.ca, book a relevant professional consultation. I think I'll be in a position to help you out with that. All the information is there on our website, and I'll see you in the next one. Bye now.